Hello, welcome to our classes. I am Dr. KK Misra. This video tutorial is on Companies Act 2013. This is in series of the key highlights which I have been covering for the past, different parts. Now this is part 6. This is on administration and management. The 2013 Act also intends to improve corporate governance by requiring disclosure of nature of concern or interest of every director, manager, any other key managerial personnel, and relatives of such a director, manager, or any other key managerial personnel, and reduction in threshold of disclosure from 20% to 2%. This is the change which has been brought into the Companies Act 1956. The term key managerial personnel has now been defined in the Companies Act 2013 and means the chief executive officer, managing director, manager, company secretary, whole-time director, chief financial officer, and any such other officer as may be prescribed. Now, let us talk about the first term, directors. First one is woman director. The category of companies which need to comply with the requirement of having at least of one woman director are as follows. This is the new one which has been introduced in the Companies Act 1956. The detail of it has been given in section 149 clause 1st of Companies Act 2013. First one is every listed company within 1 year from the commencement of second proviso to subsection clause 1 of section 149. Second, every other public company that has paid up share capital of 100 crores of rupees or more or a turnover of 300 crore of rupees or more within 3 years from the commencement of second proviso to subsection 1 of section 149. While this new requirement will go a long way in encouraging gender diversity, it has already created quite a stir in the manner in which companies will ensure compliance. Now, this is regarding number of directorship. Mind it, not director, rather number of directorship. The Companies Act 2013 increases the limit of number of directorships that can be held by an individual from 12 to 15. Section 49 clause 1st of Companies Act 2013. Third, one director to be resident in India. This is a new requirement with respect to directors is that at least one director to have stayed in India for at least 182 days in the previous calendar year. This detail of it is given in section 149 clause 3 of Companies Act 2013. This requirement appears to be a departure from the focus given in the 2013 Act towards use of electronic mode such as use of video conferences for meetings and electronic voting. With the increasing use of electronic media, the need for a director to be resident in India for a minimum amount of time becomes redundant. Fourth, independent directors. One of the significant aspects of the 2013 Act is the effort made towards incorporating some of the salient requirements mandated by the SEBI in clause 49 of the listing agreement in the Companies Act 2013 itself. Viewers, let me tell you that here I am discussing only the changes which have been brought in the previous year, Companies Act 1956, which is now known as Companies Act 2013. I am not going to cover every detail of it. Now, to this effect, the 2013 Act requires every listed company to have at least 1/3 of the total number of directors as independent directors. This is a point to be noted. Further, the central government in the draft rules has prescribed the minimum number of independent directors in case of the following classes of public companies. This is in detail given section 49 clause 4 of Companies Act 2013. 1. Public companies having paid up share capital of 100 crore of rupees or more. 2. Public companies having turnover of 300 crore of rupees or more. 3. Public companies which have in aggregate outstanding loans or borrowings or debentures or deposits exceeding 200 crores of rupees. The Companies Act 2013 also states that companies will have a period of 1 year to ensure compliance with the 2013 Act and the rules that are framed. Here, conflicting requirements, this may be made clear. While there have been attempts to harmonize the requirements of SEBI and the 2013 Act was made, there are several aspects relating to independent directors where the requirements of the 2013 Act differ from that of clause 49 of the equity listing agreement. The requirements of the 2013 Act and the manner in which they differ from those under the clause 49 of the equity listing agreement include the definition itself. The other main differences are as follows. Clause 49 does not require the board to exercise its judgment and opine on whether the independent director is a person of integrity or has relevant expertise or experience. This requirement poses difficulty in terms of the manner in which integrity of an individual can be assessed by the board. Also, clause 49 does not require examination of the independence of the relatives of independent directors, extending the disqualification of the independent directors to consider the pecuniary relationship of the relatives would pose unnecessary hardship for the independent directors. The qualification of the independent director has been left to be specified later. The 2013 Act brings the constitution of the board in India at par with the other international capital markets, that is, by mandating at least one-third of the board to be independent directors in case of listed companies. Whereas, the SEBI requirements are where the chairman of the board is a non-executive director, at least one-third of the board should comprise of independent directors, and where the non-executive chairman is a promoter of the company or is related to any promoter or person occupying management positions at the board level or at one level below the board, at least one half of the board of the company shall consist of independent directors. So this clause should be made very clear to all of you, because from this clause, this section, a lot of questions can be generated in different competitive examinations. Differing compliance requirements with respect to the appointment of independent directors, remuneration thereto imposed by multiple regulators will lead to hardship as well as increased cost of compliance for companies. The 2013 Act also limits the tenure of office of an independent director to a maximum of 2 tenures of 5 consecutive years, with a cooling off period of 3 years between the two tenures. During the cooling off period of 3 years should not be appointed in or be associated with the company in any other capacity, either directly or indirectly. The detail of it is given in section 149 clause 11 of Companies Act 2013. It is also relevant to note that the MCA had released the Corporate Governance Voluntary Guidelines in 2009, which permitted 3 tenures with other conditions similar to those discussed above for an independent director, while as per the clause 49 of the equity listing agreement, an independent director cannot serve for more than 9 consecutive years. The stock options, as per the Companies Act 2013, an independent director will not be eligible to get stock options but may get payment of fees and profit linked commission subject to limits specified or to be specified in the rules. This detail of it is given in section 49 clause 9 of Companies Act 2013. This again is in contradiction with SEBI's requirements, whereby for the purpose of granting stock options, the term employee includes independent directors also. Now, another point here is data bank of independent directors. The 2013 Act makes the appointment process of the independent directors independent of the company's management by constituting a panel or a data bank to be maintained by the MCA, out of which companies may choose their independent directors. The proposal has its origins in the report of the 21st Standing Committee on Finance, wherein it was acknowledged that preparation of a data bank of independent directors could vest with the regulatory body that may comprise of representatives of MCA, SEBI, Reserve Bank of India, professional institutions, chambers of commerce and industry, etc. The detail of it is given in section 150 of Companies Act 2013. A drawback of constituting a panel of independent directors is that it may discourage people from registering with the panel and in that sense limit the options available to a company for appointment of independent directors. Now, Code for Independent Director. The 2013 Act also includes Schedule Fourth Code for Independent Directors, which broadly prescribes the following for independent directors: professional conduct, role and functions, duties, manner of appointment, reappointment, resignation or removal, holding separate meetings, evaluation mechanism. The code appears to be mandatory, which would lead to some of the following concerns. The code states that an independent director shall uphold ethical standards of integrity and probity. However, what would constitute ethical behavior is not defined and is open to interpretation. The code does not give any cognizance to the need for training for the independent directors. The code refers to appointment of independent directors by the board after evaluating certain attributes. The concern that remains unaddressed is the manner in which companies need to carry out an assessment of the attributes of an independent director as specified under manner of appointment in the code from the data bank maintained by the MCA. Now, liability of independent directors. The 2013 Act also makes an attempt to distinguish between the liability of an independent director and non-executive director from the rest of the board and has accordingly inserted a provision to provide immunity from any civil or criminal action against the independent directors. The intention and effort to limit liability of independent directors is demonstrated from the section 149 clause 12 of the 2013 Act, which inter alia provides that liability for independent directors would be as under: only in respect of such acts of omission or commission by a company which had occurred with his knowledge, attributable through board processes, with his consent or connivance, or where he had not acted diligently. This section seeks to provide immunity from civil or criminal action against independent directors in certain cases. Further, in accordance with the requirement of section 166 clause 2 of Companies Act 2013, whole of the board is required to act in good faith in order to promote these objects of the company for the benefit of its members as a whole and in the best interest of the company, its employees, the shareholders, the community, and for the protection of the environment. By virtue of this section, the duty of independent directors actually goes beyond its normal definition and is not restricted to executive directors only. It is amply clear that independent directors have little or no defense and their obligations continues to remain a debatable topic since they would still be treated equivalent to the other directors by holding them responsible for decisions made through board processes. Now, here we'll talk about the appointment of an additional director. It is pertinent to note that in order to discourage inappropriate practices, the Companies Act 2013 states that any person who fails to get elected as a director in the general meeting can no longer be appointed as an additional director by the board of directors. The detail of it is given in section 161 of Companies Act 2013. Now, additional compliance requirement for private companies. Specifically for private companies, yes, there are certain increased compliance requirements mandated for private companies, which till now were mandated only for public companies and private companies which are subsidiaries of public companies. These include the following. First, appointment of director to be voted individually. Second, option to adopt principle of proportional representation for appointment of directors. Next, ineligibility or account of non-compliance with the section 274 clause first sub clause G now extended for appointment or reappointment as a director in a private limited company also. So this was all about this video tutorial, the detail of it, the administration and management. I hope that have been details of this has been very clear to you. I hope that you have liked it, and if you have liked it, please do not forget to subscribe my YouTube channel or classes and press the bell button and pass it on to others, those who are needy now and in the future. Thank you. Please like, share and subscribe. Thank you very much. Have a nice time. Best of luck.